Good morning. Today, it's the afternoon. I'm so out of it. I've been having too many speeches and too many meetings. I apologize. Good afternoon. The subcommittee today is meeting to review H.R. 1346, the Medical Device Safety Act of 2009. We've made huge advances in medicine over the last few decades. New and emerging technologies hold promises that our great-grandparents could never have imagined. Many illnesses that were once a death sentence are now preventable, curable, or at least manageable through modern medical treatments. However, though these medical advancements offer huge benefits, they also present a certain amount of risk. For example, there have been recent stories of patients who have suffered serious injuries from defective FDA-approved devices like implantable cardiac defibrillators and pacemakers. And if I use an example from my home state of New Jersey, there was a young girl, 14 years old, who was one of the victims affected by a faulty medical device. Last year, she felt a very strong pain through her body that she described as a horse trampling me. Eventually, she realized that her implantable cardiac defibrillator was shocking her, and it continued to do so 18 times. When the paramedics arrived at the scene, they found this little girl lying on the floor, begging for someone to remove the device from her body. She spent the next 4 days at a children's hospital waiting to have the surgery to remove the device. Though the faulty device is no longer inside her body, she still suffers from significant anxiety triggered by the slightest heart palpitation or any beeping sound she hears. The medical costs this family in New Jersey now bears as a result of the surgery and side effects are tremendous. Unfortunately, I use that example of the little girl from New Jersey, but the problem is that she and her family have no opportunity for legal recourse, and she's not alone in this problem. In February of last year, the U.S. Supreme Court deliberated the Regal versus Medtronic case and made a decision that, in effect, relieved medical device companies from the responsibility of ensuring the safety of their products. The Supreme Court ruled that patients could not receive compensation for their injuries, medical expenses, and lost wages caused by defective pre-market approval PMA devices or inadequate safety warnings. Now, this decision, in my opinion, ignores congressional intent and is contrary to the medical device amendments, or at least the way they've been interpreted, since the legislation was passed in '76. For the past 30 years, federal regulation through the FDA, together with tort liability, played crucial roles in protecting consumers from risky devices. Already, this Supreme Court decision has had a devastating impact on patients who have been harmed by defective medical devices. For example, a federal judge in Minnesota threw out more than 1,400 lawsuits filed by patients who had defective heart defibrillator wires or leads implanted. Many of them died as a result. And the judge based his decision on the Regal case and noted that the only way to remedy the situation was for Congress to step in. It is crucially important that all the major stakeholders involved in manufacturing medical devices make patient safety their main priority. We must be certain that we're taking every step necessary to ensure that the technologies designed to save lives are not placing people in danger. And much of the data used by the FDA in pre-market approvals for both drugs and devices is limited in the number of individuals who are monitored, as well as in the time frames that they're collected. These studies are vital in making safety and efficacy determinations, while at the same time getting life-saving treatments to patients in a timely fashion. However, the Institute of Medicine has recommended that the risks and benefits of these treatment options should be monitored through the entire life cycle, and this means that the manufacturer has a responsibility for the safety of their product for as long as it's being used by patients, not just during pre-approval trials. Until last year, the state court system provided an additional incentive for companies to actually follow this recommendation. Unfortunately, the Regal versus Medtronic's case and its effects have removed that incentive and provided medical device companies with blanket immunity. The court premised its decision on the theory that FDA approval adequately protects patients from unsafe medical devices, and that theory, in my opinion, has proven false time and again. So that's why I, along with Mr. Waxman, our full committee chairman, introduced the Medical Device Safety Act of 2009, the bill we're examining today. This bill protects patients from dangerous and defective devices by correcting the court's flawed interpretation of the medical device amendments of '76. The bill explicitly clarifies that state product liability lawsuits are preserved and put safety first by eliminating the blanket immunity that medical device companies currently enjoy. There is precedent for this, as the Supreme Court just a few months ago ruled in favor of a plaintiff in a case against a drug company. In that case, the court upheld congressional intent and placed the responsibility for making a safe product squarely within the company's purview. And it's crucial, in my opinion, that we act now to provide patients in need of a medical device with that same certainty. So I want to thank all of you. I'm going to introduce you after we have the opening statements from the rest of the committee. And I now recognize my colleague from Georgia, Mr. Deal.
Thank you, Mr. Chairman. Thank you for having this hearing today, and thanks to the witnesses who come to share their position and opinion on this legislation, H.R. 1346. Although the legislation is less than 1 page in length, the legislative impact of the legislation is significant and I think cannot be discounted based on its own brevity. The United States is and should remain at the forefront of medical device innovation, a position which I believe would be undermined by this bill. Medical industry in the United States has grown as a worldwide leader in innovation and development, providing therapeutic advances for patients and their physicians to treat complicated medical conditions and as the advance of science and medicine in our country continues to grow, and this has been shared around the world. Critical life-saving devices such as neurostimulation devices, cardiac defibrillators, and pacemakers have improved the longevity and the quality of life for countless Americans who depend on these technologies every day. What must be considered when evaluating the merit of legislation to eliminate preemption of state tort claims with respect to these critical devices is the resulting impact which will occur on the development of new products. Eliminating preemption will stifle innovation, in my opinion, will increase the risk among manufacturers who are on the cutting edge of medical device development, and prove detrimental to patients in dire need of innovative solutions to complex, hard-to-treat medical conditions. In the case that the Chairman referred to of Regal versus Medtronics, the United States Supreme Court, as well as 6 out of 7 federal circuit courts, confirmed the widely held view that the Medical Device Amendments Act, MDA, does indeed preempt state common law claims with respect to devices approved through the pre-market approval process, which is the most rigorous approval process for medical devices. What seems to have been forgotten is that the vast majority of state common law claims involving most medical devices are still permitted. First, the preemption provision provided under the MDA applies to approximately 2% of devices approved by the FDA each year, those which are approved under the pre-market approval pathway. The majority of medical devices each year, those which are approved through the 510K process, are not preempted under current law. Second, it is also important to remember that if a device is improperly manufactured or the source company withholds information from the FDA or misleads the FDA and consumers about the safety and effectiveness of the product, the MDA does not preclude common law tort liability cases in state court. Patients who incur harm are fully capable of pursuing such just recourse for their harm. I urge the members of this subcommittee to take the same approach which the FDA takes in approving these devices by evaluating the risk versus benefits of this legislation. Given the detrimental impact H.R. 1346 will likely pose on development and innovation of promising new technologies promoted by a heightened litigious environment surrounding these products, we will be instituting roadblocks contrary to the overall mission of this committee and of the Food and Drug Administration, which has the responsibility of improving the health of American patients across the country. Thank you, Mr. Chairman. I look forward to the testimony of the witnesses, and I yield back.
Thank you, Mr. Deal. Chairman Waxman.
Thank you very much, Mr. Chairman. I welcome the witnesses to today's hearing as well. Until February of last year, when Americans were injured by defective medical devices, they had a remedy. In most states, they were able to sue the manufacturer of that product for damages in state court. In fact, the only way patients can obtain compensation is to bring a lawsuit under state law. But in February 2008, the Supreme Court dramatically altered this landscape in its Regal versus Medtronic decision. The court ruled that so long as FDA has approved a medical device, patients injured by that device can no longer seek compensation to help them deal with their permanent disabilities, their inability to work, and their costly medical procedures. Ironically, the decision applies only to the most dangerous and most complex devices, the kind of devices that, when they malfunction, often result in death or severe physical impairment. This decision has already had a devastating impact. There are over 1,400 cases brought by injured patients that have been thrown out. We learned that another 300 cases were terminated under Regal. Countless other lawsuits will never be brought. In the wake of the court's decision, it doesn't matter how badly a defective device harmed a patient. It doesn't matter how egregious the device manufacturer's conduct was in marketing a defective device. Patients have no recourse and no ability to be compensated for their injuries. The court's decision was bad for Americans in another way, too. It has destroyed one of the most powerful incentives for safety, the possibility of liability. We know that some device companies have hidden and manipulated important safety data. Some have failed to report serious adverse events. Some have failed to disclose known defects. Yet under the court's decision, even if a company withholds information about potentially fatal defects from physicians, patients, or the FDA, it is still immune from any liability for its actions. In the absence of liability, all the financial incentives will point medical device companies in the wrong direction. Tragically, the end result is that these abusive practices will undoubtedly multiply. Now, some would counter the FDA will be there to protect against these abuses. FDA approved these devices, so why should we have juries second-guessing FDA's expert judgment? Well, as a result of chronic underfunding and weak leadership, FDA's ability to protect the public has plummeted. And in fact, FDA's own science board issued a report saying that the agency is so starved of resources that, quote, American lives are at risk, end quote. But even if we were to give FDA every penny it needs, there would still be a compelling argument for our system of state liability laws. That's because we operate on a model that relies on the industry to innovate, research, develop, and market their medical products. FDA is not the only one playing this role, so the device companies themselves will always know more about their products than the FDA. And here's another problem. The clinical trials upon which FDA relies to approve drugs or devices are often too small to detect less frequent risks. Some risks can only be detected when the drug or medical device is used in the population at large. I was here, as well as Mr. Dingell and very few others on the committee, when the medical device law was adopted. And at no point in the consideration of that legislation did we expect that the preemption language, which was that the FDA has a sole responsibility to approve a product, mean that we were trying to preempt the states from the liability laws. Liability laws have always been in place to serve a very important role, and I was disappointed to see the Supreme Court come up with the decision it did using that language, which of course they did not find in the medical drug section to preempt the state liability laws. I hope that we will overturn the decision of the Supreme Court and allow state laws to continue to play an important role in protecting consumers. Thank you, Mr. Chairman.
Thank you, Chairman Waxman. The gentleman from Illinois, Mr. Shimkus.
Thank you, Mr. Chairman. We're going to hear many difficult and tough stories today, but I know we have Mr. Kinsley here to talk about the other side, and I would just plead for people to remember the thousands of the people who have greatly benefited from, in this case, that one aspect I know is the cerebellar or the spinal cord stimulators. And I had a chance to visit with a couple individuals today, Mike Roman from DePere, Missouri, and Adam Hammond, who was an Army guy, and I had a chance to visit. And their stories are just as compelling of the serious pain in which they were under, to a point where they were of no benefit only to the pharmaceutical companies, who had to medicate them severely to ease their pain. They were not able to function in today's society, but because of this technological advance, one walked into my office, the other one jumped off the wheelchair, talked to me about how their life had been changed for the good. Now, now the doctors have the Hippocratic Oath, which says, "First, do no harm." We better be very, very, very careful that in trying to fix the problems of some, we don't turn over the opportunity for this really new life-giving technology to be available for people who desperately need it. So, Chairman, I would preach caution and concern for both sides as we move forward, and I yield back the balance of my time.
Thank you, Mr. Shimkus. Chairman Dingell.
Mr. Chairman, I thank you for holding today's legislative hearing on H.R. 1346, the Medical Device Safety Act of 2009. I am an original co-sponsor of this legislation, and I strongly believe that it is necessary to reinforce congressional intent on a very important policy matter. I want to thank the witnesses who've joined us today and look forward very much to hearing their testimony. Prior to 1976, in the absence of federal regulation, states enacted their own laws governing medical devices. So in an effort to streamline medical device safety policy, the Congress acted. In 1976, we passed the Medical Device Amendments. Our legislative intent was to give the FDA the power to regulate the approval of medical devices for U.S. consumers. We concluded that it was necessary to include a preemptive clause to make sure that federal regulation through FDA preempted state regulation on medical devices. We included no other preemptions. We did not, I note, however, expressly nor implicitly do away with state liability actions. Unfortunately, the U.S. Supreme Court in Rigo v. Medtronic, Inc., 2008, decided to create legislative intent where there was none, and immune medical devices from state product liability law. Now, people complain about activist judges. Here's a fine example of people who are running out to find a congressional intent where none existed. I urge my colleagues to remember that there are three coordinate and co-equal branches of the federal government with distinctive duties and responsibilities. The appropriate application of federal preemption should be determined by the Congress, not concocted in preambles to federal regulations or decided through case law. Though in 2008, the Rigo decision, an activist judiciary decided to constrict state authority in the way Congress never intended. Therefore, it is time for the Congress to act properly, to exercise our authority to correct this clear judicial overreach. In this instance, the use of tort litigation is beneficial because it will protect consumers where federal regulation fails to anticipate latent danger in medical devices. And when the Congress wants to preempt, I think it has a great talent in saying so in the legislation. None, I repeat, is here to be found. The Food and Drug Administration, I want to note, has been starved for resources for a number of years. This has made it almost impossible for them to adequately ensure the safety of products they regulate. And all you've got to do is look back at the flood of unsafe foods, commodities, pharmaceuticals, and other things coming in from China and elsewhere abroad, as well as things that are slipping into our American economy because of the total inability of Food and Drug to properly protect American consumers. It is to be noted that FDA does not have the ability to ensure the safety of the products they regulate. FDA's IT systems are antiquated. Its science base is eroded. Its laboratories are a joke. And it does not have adequate personnel or, quite honestly, adequate authority to deal with its responsibilities. I will note parenthetically I have a good bill, H.R. 759, that will go a long way in addressing this issue, and we can get back to protecting our people the way we should. And until this can be done, we very frankly need to see to it that citizens and attorneys general have the capacity to properly protect American consumers. So, until we properly equip FDA with the resources to do its job, consumers should have the ability to seek redress under the law. And I would note that of late we have seen many instances where a lot of do-gooders have run out and stripped federal agencies of the authority to regulate, either legislatively or in courts. We saw it in securities, and we saw Enron follow, and a lot of other bad things happen. We saw them do it with regard to banks in the repeal of Glass-Steagall and the deregulation of the securities industry and the deregulation of banks. And all of a sudden we found that we had a magnificent depression on our hands because of abuses of the banks repeated, being the same things that they did in 1920 and 29. Having said this, there may be a day come when we will no longer need state liability to protect consumers from defective medical devices. Unfortunately, that day is not here, and it isn't likely to come until we've dealt with the weakness of Food and Drug, its inadequate budget, and its total inability to properly protect American consumers. For those that paid attention in 1976, we made our intent clear. For those unfortunates needing clarification, we can point to H.R. 1346. It tells people what we had in mind then and what we have in mind now. Thank you, Mr. Chairman, for holding this hearing. I look forward to receiving the testimony of our witnesses.
Thank you, Chairman Dingell. The gentleman from Missouri, Mr. Blunt.
Thank you, Mr. Chairman. Thank you for holding this hearing on the Medical Device Safety Act of 2009. It's certainly important that we carefully consider the possible impacts this legislation could have on patients and the companies that produce life-saving and life-changing devices for those patients. It's extremely important that any medical device on the market undergoes a thorough and appropriate approval process to ensure the safety of the patients who need them. If a company fails to ensure they are manufacturing the highest quality devices and that there are adverse impacts on the patient, then they should be held responsible. On the other hand, if the manufacturer has done everything in its power to put a device through the proper approval processes, correctly manufacture the device, and properly inform its customers, it can't be held responsible for situations beyond its control. We need to make sure, as we look at this bill and this subject, that companies are not subject to overly burdensome regulations because this would ultimately cause patients to suffer in the form of decreased access and decreased innovation of medical devices. I look forward to working with you, Mr. Chairman, with Mr. Deal and the subcommittee as we move forward on this issue. I also look forward to the panel today.
Thank you, Mr. Blunt. Mr. Murphy of Connecticut.
Thank you very much, Mr. Chairman. Just very briefly, I'd like to thank you for holding this hearing today. And I understand that the focus of much of our discussion today is going to be the precedent set in Regal. But as someone new to this debate, I look forward to hearing from the panel about their ideas on how to truly make the fundamental reforms to the FDA process that Mr. Dingell and many others have referenced. I absolutely believe that tort law can be an effective check against unsafe products, but I also understand that it can be a patchwork check on those products. And so I look forward to hearing today both about the precedent that has been set and our opportunity to transform it. But I also look forward to hearing from this panel and those who will come before this committee in the future to hear about how we can truly put teeth into the FDA. There's no reason to give up on that process, and I stand ready at the very least to be part of a process by which we can make that approval process work once again. Thank you, Mr. Chairman.
Thank you. Gentleman from Indiana, Mr. Boyer.
Thank you, Mr. Chairman. I want to comment on 2 points. One came from my dear friend, Mr. Waxman. The reason I need to make this point is that he talked about how the FDA right now, being an underfunded agency, is ill-equipped to protect the public because it has been woefully underfunded. All right, let's stop and think about that for a moment. Woefully underfunded. Mr. Waxman, what did you just do and this committee just do with regard to tobacco legislation? You gave it a new mission on top of a core mission that is counter to its culture. And if, in fact, we have an agency that's underfunded, we should be funding the agency and making sure that it does its job, and so that the best minds in the world can assess these products to make sure that we have the gold standard of safety. Not to say, well, let's turn it over to juries and judges and the cleverness of trial lawyers. That is the wrong place. That is the wrong venue. It is the wrong jurisdiction to have the supervision of medical devices. So that is a bizarre logic for me. Second point, with regard to my other dear friend, Mr. Dingell, talking about activist judges. Boy, this is in the hands of the beholder when conservative courts are now considered activist courts because of its interpretation of the law. And now, whom are they embracing? No, who they're embracing is the circuit, the 11th Circuit, that is out of step with all other circuits, is who Mr. Waxman is embracing. For the years that I served on the Judiciary Committee, I sought to sever the 11th Circuit. I'd break it into 6 parts if I could. It is the most bizarre circuit with regard to its judgments for the country. So for us as a committee to embrace the 11th Circuit as though that is, in fact, the judgment that should be made for the whole of the country, I think is twisted logic. Now, I agree with the judgments of the Supreme Court. I think they made the right decision. I think they brought clarity to the issue. And the other point I want to make is that in the court's decision in Regal, it confirmed, yes, that the MDA does preempt state common law with respect to devices approved through the pre-market approval process. But it further confirmed that the manufacturer, if it engages in wrongful conduct, the manufacturer can be held liable. Now think about if some of us, if we wanted to go to the marketplace at risk, pool our capital, push the bounds of science, and we've created something, we go through the approval process, we do everything that the FDA says we're supposed to do. Yet what? We want to turn that over, even though I've done everything we're supposed to do, to all these state court jurisdictions? If I'm the manufacturer and I've got a state out there that is out of step and bizarre, I will not market that product in that state. And then the people who live in that state then will suffer. Is that the type of equity we bring to America? I don't think so. I yield back.
Mr. Braley of Iowa.
Thank you, Mr. Chairman, for holding this important hearing. It's a very important distinction to draw that what we're talking about today is a restoration of rights that existed in this country for over 100 years, not the creation of some new cause of action. In fact, Justice Ginsburg, in his dissenting opinion, referred to this as a radical curtailment of state common law remedies. And as someone who has not only researched, briefed, and argued federal preemption cases in both state and federal courts, I can tell you from personal experience that the key issue in every federal preemption case is the original intent of Congress as expressly stated, and that in the application of the law to that issue, the question is always a presumption against preemption because it is such an extraordinary action to take. And in fact, the court, in its opinion, cited the legislative history, which is always one of the first things you look at in determining congressional intent. And it referred specifically to the Senate sponsor of the bill, Senator Kennedy, who noted at the time the bill was introduced, the legislation is written so that the benefit of the doubt is always given to the consumer. After all, it is the consumer who pays with his health and his life for medical device malfunctions. And it also quoted Chairman Waxman, who I'm sure would be surprised that he was being cited as one of the contributing members whose congressional intent shaped the court's eventual outcome. One of the things that was also mentioned in the dissenting opinion was the perverse effect of immunity. And the court focused on the fact that at the time this act was brought before Congress in 1976, it was at a time when the entire industry, according to the judgment of Congress, needed more stringent regulation. And if you look at Justice Scalia's opinion, he notes that when these devices enter the market, they have never been formally reviewed under the MDA for safety or efficacy. And, Mr. Chairman, I'd like to note, as Chairman Waxman referred to earlier, that just today in the United States District Court for the District of Minnesota, 300 additional people who were injured or killed by defective medical devices had their cases thrown out because of this decision. And I would ask unanimous consent for the ruling that was handed down today to be included as part of the record.
Without objection, so ordered.
Now, one of the things we often hear about is reasons that this bill should not be passed. Let me give you 4 conservative reasons to support the passage of this bill. Number 1, it holds corporate wrongdoers accountable when they injure or kill people with defective devices. Number 2, it does, when you provide immunity to medical device manufacturers, you create greater exposure for the physicians who install them and the hospitals where they're installed. Number 3, as Dr. Mizell noted last year during our hearing, it results in cost shifting to U.S. taxpayers who end up paying for the care of these patients who have no other remedy. And 4th, we see a flood of defective medical devices flowing in from overseas. That's a conservative reason right there, and that's why we need to pass this bill.
Thank you. Gentleman from Pennsylvania, Mr. Pitts.
Thank you, Mr. Chairman. Thank you for convening this hearing. The bill we're discussing today, H.R. 1346, would overturn the 8-1 Supreme Court decision in Regal versus Medtronic. In this 2008 decision, the court held that the preemption clause contained in the Medical Device Amendments Act bars common law claims challenging the safety of a medical device granted pre-market approval by FDA. This decision is extremely limited in scope. Only those devices that receive pre-market approval, or PMA, approximately 2% of the new medical devices marketed per year have express preemption. Regal also makes it clear that preemption does not apply to PMA devices if the manufacturer withholds information from the FDA, misleads FDA about the safety or effectiveness of its product, or the company manufactures a product improperly. In such a case, the company can be sued for its wrongful behavior. The PMA process is scientifically rigorous. The FDA spends an average of 1,200 hours reviewing each application, including the device's proposed labeling. And in granting PMA, the FDA has determined that the probable benefit to health from the use of the device outweighs any probable risk of injury or illness from use. Once a device is approved through the PMA process, the manufacturer is subject to reporting requirements, including informing FDA of new clinical or scientific studies regarding the device and reporting incidents in which the device failed or contributed to significant injury. FDA can withdraw approval if a device is found not to be safe or effective. FDA can order a recall if it is determined that a reasonable probability exists that a device could cause serious injury or death. What would the consequences be if these life-saving complex devices did not receive express preemption, as would be the case if H.R. 1346 became law? Companies that manufactured and labeled their products according to FDA-approved standards could be sued in state courts and found at fault if a device causes injury or harm. A lay jury would be presented with a case in which an individual was harmed by a device, and its judgment would be substituted for that of the FDA. 50 courts in 50 states could each determine what standard a device should meet. Innovation would be stifled. Venture capital could dry up with the threat of litigation once a product hits the market. Manufacturers could pull products from the market or refuse to sell them in certain states as a result of court cases. People who desperately need these life-sustaining devices may not have access to them. No device, no matter what the approval process, will ever be 100% safe and effective. But when FDA grants pre-market approval, it has judged that the benefits to the population at large outweigh the risk to the population at large. The Regal case was decided properly, and H.R. 1346 is simply bad policy. We all want only those medical devices that are safe and effective be on the market. H.R. 1346 will not help us to achieve that. I look forward to hearing the witnesses today, and I yield back.
Thank you, Mr. Pitts. The gentleman from Texas, Mr. Burgess.
I thank the chairman. I thank the witnesses for being here with us today and listening to our opening statements. We'll listen to yours in just a moment. Certainly, the Food and Drug Administration categorizes devices into three categories. Class 1 devices are subject to minimal requirements. Some easy examples of that would be latex gloves and bedpans and urinals. Class 2 devices are subject to more requirements and include such items as hearing aids. But H.R. 1346 is not aimed at Class 1 and Class 2 devices. It is aimed at high-risk devices known as Class 3. Class 3 devices are considered high risk because they are complex and used to support or sustain human life, or whose use is of substantial importance in preventing impairment of human health. They are most certainly life-changing devices with no 100% guarantee of safety or efficacy. With Class 3 devices, there are calculated risks involved. Now, weighing the risks, the interests of a manufacturer against the life of a human being, no question about what side you come down on. Come down on the side of the human being. But preemption does not do that, nor does preemption bar state common tort laws. Preemption is not a get-out-of-jail-free card for bad actors taken to court. If a medical device manufactured violated the essential premise of producing a safe product, there are still remedies, despite the Supreme Court's 8-1 ruling in Regal versus Medtronic. But what the Supreme Court recognized in Regal versus Medtronic is two things. First, the Supreme Court found that pre-market approval for devices by the Food and Drug Administration is rigorous, even arduous. 1,200 hours or more of review for each potential device. You have to undergo clinical trials, and a company must give countless pages of documentation to the scientific experts at the Food and Drug Administration. And review by the Food and Drug Administration does not end with pre-market studies. Post-market approval is continuous and frequent. If a manufacturer fails to maintain the Food and Drug Administration's standard of approval by being disingenuous or failure to be transparent, then approval can be rescinded. The strenuous nature of pre-market approval process is evident in the exponential rise in the 510K applications, where a device is allowed to go to market if there are what are known as substantially equivalent devices. Now, Mr. Chairman, I've requested a hearing on the 510K process in March of this year. I am concerned about how devices are being approved at the FDA. If the FDA is broken, if the FDA is under-resourced, as Chairman Waxman suggested, if the FDA is understaffed and underwater, if the FDA is ill-equipped, inadequate, or severely underachieving in its Class 3 medical device process, then let's do what's within our power and fix the FDA. This subcommittee is not tasked with fixing the legal system. H.R. 1346 is tort reform, but it's tort reform at its very worst, utilizing the worst possible mechanism. H.R. 1346 would create a haphazard system, a virtual patchwork of device standards, where lay jurors are elevated to the same standard of expertise, knowledge, and grasp of science as someone on an FDA advisory panel. Furthermore, an attorney general in California, or an ambitious attorney general in New York, or an even-keeled attorney general in Alabama could each create their own sensational trial with sensational damage figures regardless of what the Food and Drug Administration does. If there ever was congressional intent in the enactment of the Medical Device Act of 1976, it would be this: federal ceilings to tort liability as it relates to medical devices must exist as a necessity to encourage innovation and a healthy progress in medicine. Without a ceiling, no doctor will ever use a medical device and risk his or her entire professional future to a jury. And no manufacturer will ever undertake the risk of producing a single device where a single error will result in the destruction of the entire livelihood of that company. The science of devices should not be in the judicial branch. The judicial branch should determine the law, and the law here is written by Congress. So the solution regarding medical devices is to give the Food and Drug Administration the resources that they need to do the job that they have been tasked to do, and not to enact H.R. 1346. I thank you, and I'll yield back the balance of my time.
Thank you. Our ranking member, the gentleman from Texas, Mr. Barton.
Thank you, Mr. Chairman. I'm going to submit my full statement for the record, but I do want to read one paragraph from the Republican Staff Committee brief for this hearing about H.R. 1346. And before I do that, let me say I do appreciate that we're having a legislative hearing. I wish it were on another bill, but at least we're having a hearing. But let me just put in a nutshell what my position is and what I think most of the Republicans on the subcommittee's position is. Enacting H.R. 1346 will not only overturn the Supreme Court's 8-1 decision in Regal versus Medtronic, it will also severely disrupt the innovation in the medical device industry that has existed since the enactment of the Medical Device Amendments Act of 1976 to the Federal Food, Drug, and Cosmetic Act. This disruption will decrease patient access to life-saving medical devices, threaten the U.S.'s status as a global leader in medical device innovation, and dramatically increase the number of lawsuits against device companies. So, Mr. Chairman, again, thank you for holding the legislative hearing, and we will certainly listen to our witnesses, but I would hope that you have no intention of moving this bill. There are more important bipartisan issues that we can work on together for the good of the country. This is not one of them. With that, I yield back.
Thank you, Mr. Barton. Next is the gentlewoman from Tennessee, Ms. Blackburn.
Thank you, Mr. Chairman, and I thank our witnesses for their patience today. And we've had a lot of conversation so far about the bill that you're going to testify on. I think it's important to make just a couple of notes as we move forward to your testimony, and I will submit my full statement, Mr. Chairman. It was, as Chairman Dingell said, over 30 years that Congress enacted the medical device amendments. They were there to create a uniform national process for evaluating the medical devices. They have done that. Subsequently, the FDA successfully implemented the pre-market approval process, which gives the specific guidance to the medical technology companies that they follow to ensure the safety of those devices. They spend an average of 1,200 hours reviewing every single application. That is a lot of time on every one of those applications. Now, common sense would dictate that the FDA and the medical technology companies are committed to making available the safest devices possible to save lives. Anyone who believes that these companies are out to purposefully make poor performing products ought to return to Business 101 and realize that companies know if you put bad products into the marketplace, it will eventually lead to a company's collapse. So in order to stay competitive, medical technology companies like Medtronic, Smith & Nephew, and Wright Technologies, which are all in my district, continue to develop and produce innovative technologies in order to save lives. Also, I'm troubled that some in Congress would weaken the current device review system in the name of consumer safety. I do think the act is misnamed. It would be a boon for trial lawyers at the expense of public safety. I think the other provision we have to look at is the device sector is responsible for almost 2 million jobs. Thousands of jobs in my district alone. I have personally toured many of the facilities and am continually impressed by the innovation, the research, and the commitment to saving and bettering lives that I have found at each one of the facilities. Thank you, Mr. Chairman. I yield back.
Thank you. Gentleman from Georgia, Mr. Gingrich.
Thank you, Mr. Chairman. Today, as a result of advances in medical technology, Americans enjoy access to a quality of health care that most nations do not. While some countries restrict or ration the types or the amount of drugs and devices that patients can access, American patients can receive the latest, the most advanced medical technology, such as an artificial hip or the latest cancer medication that will drastically improve and extend their lives. Mr. Chairman, ensuring the safety of medical devices is an absolute necessity for our continued access to quality health care. The FDA is charged with making certain that all medical devices have been thoroughly tested for safety and effectiveness before coming to the market. It is one of the FDA's primary responsibilities, and I support increased efforts in this area. Unfortunately, modern medical procedures inherently have risk associated with them, regardless of advances in technology or effective oversight. It goes without saying there are very few absolutes in this world. With this thought in mind, I look forward to the testimony of our witness today. I yield back, and hopefully we'll use some of this additional time for questioning. Thank you, Mr. Chairman.
Thank you, Mr. Gingrey.